It's the Vicki McKenna Show. Standing by on the Homesteaders Store hotline, Homesteaders Store, good people with the right stuff, Kubota Ellis Tractor and Cub Cadet, is Rick Essenberg from Wisconsin Institute for Law and Liberty. Rick, I was giving Will so much love today on a podcast I was doing with Duke Pesta. We were just showering. Could you feel it? Could you feel the love? It's great to have you, by the way.
I heard my ears were burning. I didn't know why.
It was because we were talking about you. We were actually talking about if any parents feel that their children's civil rights are being violated in the schools, to please reach out and contact Wisconsin Institute for Law and Liberty, because you mentioned some of the cases you had been working on. So, hopefully people reach out. But that's not why I have you on. It's on a couple of things. One, Janet Protasewicz, Justice Protasewicz, has declined to recuse from the MAPS case. 2, what the MAPS case could do. 3, whether impeachment is even worth pursuing, and what other options might we have. Or 4, is it just, a hellscape? It's great to have you, as I said, though. Let's start with the decision to not recuse herself, which I disagreed with, but we're stuck with it, right?
Well, it's going to be an issue on appeal, or at least it's potentially an issue on appeal if the case comes out in a way that those who asked her to recuse don't like. Because there is a case called Caperton, and in Caperton, the Supreme Court said there are some circumstances under which the constitutional guarantee of due process might require a judge to recuse himself or herself. She wrote an opinion here in which she discussed Caperton. She concluded that she didn't have an obligation to recuse, but my suspicion is that if this case goes against the people who are trying to hang on to the maps, that they may ask the Supreme Court to take a look at that, and that will be a federal issue, and whether the court will want to do that or not is something that's impossible to predict.
Right. The United States Supreme Court would look at this. So the case itself, whatever happens with the maps, what we're hearing is that the left-wing majority on the Wisconsin Supreme Court wants to tie that to the Wisconsin Constitution, but she may face a federal appeal because of this particular Caperton case you're talking about.
There could be a federal issue over the recusal. There are other ways that a federal issue can come up, but if the court bases its decision with respect to the constitutionality of maps solely on the Wisconsin Constitution, then it is probably the case, although we can't be absolutely certain, as a general rule, the United States Supreme Court does not review state Supreme Court decisions about what the law of the state is. And so the United States Supreme Court would not have jurisdiction to take this case up and say that the Wisconsin Supreme Court got the Wisconsin Constitution wrong. It would only be able to do that if the Wisconsin Supreme Court's interpretation of the Wisconsin Constitution itself violated a federal constitutional guarantee. And that did happen in the first redistricting case. In the first redistricting case, the Johnson case that we brought, the Wisconsin Supreme Court ultimately adopted Governor Evers' legislative map. But Governor Evers had used race. He conceded that it used race to draw some of the maps in the Milwaukee area. He said that it was necessary to do that under the Voting Rights Act. We then sought Supreme Court review. We argued that it was not required by the Voting Rights Act and therefore would violate the United States Constitution, which generally prohibits the explicit use of race. The United States Supreme Court agreed. They vacated the Wisconsin Supreme Court decision. They overruled it, sent it back, and at that point, the court adopted the maps that we have today.
Okay, so Evers' maps were unconstitutional. We came up with a different set of maps. And so, again, pretty much the only way we could potentially, if they do decide to tie it to the Wisconsin Constitution, get to SCOTUS is Caperton, or does that foreclose that as well?
No, it doesn't foreclose Caperton because, Caperton,
it's a recusal case.
We should be candid. The U.S. Supreme Court said in Caperton it would have to be a rare case in which a judge's decision to recuse violated the due process guarantee, but that's an issue that could be raised. We don't know whether there's going to be an issue comparable to the voting rights issue. There could be some due process issues. We just don't know yet because obviously we're still early and we don't know which way the court's going to go.
Okay, so in the event that what happens is what a lot of people are predicting is going to happen, which of course we don't know, but in the event that the existing maps are thrown out, this is the case where they're asking for the Senate candidates to run again.
Yeah, that's a pretty extraordinary remedy. That typically wouldn't be done because it just creates a lot of problems. Our Constitution has staggered Senate terms for a reason. It doesn't want them all elected at once, and I think that depart from that would be really extraordinary. And the thing you have to keep in mind, Vicki, is that in the court's order on Friday, it declined to take up the partisan gerrymandering claim. It said it wouldn't do that. It said that it would take up this claim that the maps are unconstitutional because there are municipal islands in some of the districts. Wisconsin has a lot of situations where, there'll be the city of Racine, and then there's the part of the city of Racine which is detached from that. In the case of Racine, what's detached is a golf course. Nobody lives there. But there were islands from the town of Madison, which were sort of all around Dane County. And for 50 years, nobody has been concerned about these islands because the Wisconsin Constitution does require, to the extent that you can do it, that municipal boundaries in a municipality be kept together within an assembly district. And this was an attempt to really get legal continuity rather than fiscal continuity by including these municipal boundaries. But even if you decide that's a constitutional violation, that although there are a number of these islands, they say they're 55. We think that there may be a few less than that. They don't include a lot of voters. Some of them have no or one or two voters. There are some with more. There's one in Brown County I know of. It's got 1,000 people. But if you think the maps are gerrymandered in favor of the Republicans, it's not because of the municipal islands.
Right.
You couldn't do it that way. And so to some extent, this is a Trojan horse, I think, for the petitioners. They're hoping to get the maps thrown out because of these islands, which nobody has objected to in the past. Right? There were islands in Johnson. Governor Evers didn't object. Nobody objected on that ground. And but now all of a sudden it becomes unconstitutional and then serves as a Trojan horse to completely withdraw the maps. I think if the court does find that the maps are unconstitutional for that reason, it would be sort of a typical exercise of judicial modesty and restraint to do only what is necessary to get rid of the island, and that would not result in a substantial change in the map.
All right. So if they stick to limited, to being limited about it, it might not be horrible.
Well, I guess whether it's horrible or not depends what you think of the maps in the first place, but the change wouldn't be substantial.
Okay. So what is this? Let's assume everything's bad, and they use it as a Trojan horse to blow up the maps entirely, and, you're done. So beyond potentially an appeal on recusal or maybe some other things regarding due process, can I sue? No, I can't. Can we sue again and say the new maps are bad? Is impeachment appropriate?
What's happened here is we've got this unusual situation in which the petitioners have sued WEC. WEC says they've got no position on the merits. WEC is represented by DOJ. Now, late yesterday, a bunch of intervention motions were filed for people to intervene in the case. I represent the same people that brought the Johnson case, so we moved to intervene. Other people moved to intervene, including the governor, who is being represented by DOJ. I'm not sure how that works or whether that will continue to be the case. But there will be other people in this case, the legislatures moved to intervene, who will be arguing. And one of the things that the court has asked for is, well, if we find the maps are unconstitutional, then what should we do? How should we redraw the new maps? And I think, I suggested before that if the problem is the lack of contiguity, then they have to do no more than necessary to remove these municipal islands, which won't be much because there's not a lot of people to be moved. If they don't do that, I think that they should stick to nonpartisan redistricting criteria. That the map should be contiguous and compact. And the problem that Democrats who want to eliminate this so-called efficiency gap, which is really a misnomer, have is that compactness is not their friend. Contiguity is not their friend, because the only way that you get a legislature that looks like the statewide outcome is to gerrymander. You have to draw weird-looking districts. There is no other way to do it.
Sure, because they packed all their people in cities. The progressives like to congregate in large groups together. So I don't think that we're going to get a narrow decision, because I don't think that's what $10 million would demand in a campaign investment to Janet Protasewicz. But you are suggesting that it would be extraordinary if they did something beyond the minimal amount of a complaint to correct a complaint if, in fact, they find the maps unconstitutional. It sounds like what you're saying is the court would really be, sort of out there to do much more than if the municipal islands are unconstitutional, changing that very small thing.
I think so, and I think that the problem that we have, the problem that we have here is that. We can, believe if you want to, or that the Republicans, as I like to say, over-egg the pudding, right? They have a natural advantage because we use geographic districts. And, I am sure they did everything they could to maximize their advantage, because that's what politicians do.
That's what the Democrats would do.
If they've been in a position to do it, they would have done the same thing. They have done the same thing in other states. And so, I don't expect politicians not to be politicians, but I do expect courts not to be politicians. And so, if we get to the remedy stage in this case, I think that the court is going to have to stick to neutral criteria. These maps are going to have to be. They're going to have to pick, I think, the most compact, the most contiguous, and that may result in a map which is maps which are less Republican than the current maps, but they'll be pretty Republican.
Yeah, which again,
because of where people live.
It will be, again, contortions, legal, philosophical, whatever, logical contortions, if it turns out to be something, beyond the minimal amount. But I'm actually kind of preparing myself for extraordinary reach from this court, Rick. I know you like to hope for the best, and I'm going to just sort of let you do that. I appreciate the time on the program.
We're happy warriors, Vicki.
Yes, we're trying. I'm trying. Rick Essenberg, Wisconsin Institute for Law and Liberty. And if you would like information about Will, just go to their website, will-law.org. We'll be right back.